A new U.S. immigration law was passed today. And if you hold a green card or you're working toward one, this is not something you can afford to ignore. On the surface, it looks like good news, even long overdue progress. But beneath that headline is a split reality. For some people, this law opens doors that have been locked for years. For others, it quietly introduces new rules that could cause serious trouble if they're missed. What makes this moment so important is not just what changed, but how fast it's happening. There are benefits that kick in quickly, requirements that begin soon, and decisions you make in the next few months could shape your entire future in the United States. Many people will hear about this law too late, after deadlines pass, or after a simple oversight turns into a problem. That's why you need to understand this now, not later. Today's law isn't speculation. It isn't a proposal, and it isn't political noise. It's real. It's passed, and it applies to millions of people right now. Some green card holders will finally see relief after years of waiting. Others may not realize that habits they've had for years are now being scrutinized more closely. And there is one specific requirement buried in this law that almost everyone will be subject to, whether they realize it or not. Stay with me, because by the end of this video, you'll know exactly where you stand, what this law means for you personally, and what steps you should take to protect your status and your future. I'm Sophia, and my role here is simple: to cut through confusion and give you clear, accurate immigration updates that actually matter to your life. Today's update is one of the most important we've covered in a long time because it touches nearly every category. Green card holders, people waiting in backlogs, workers on temporary visas, and families who've been living with uncertainty for years. This new law isn't just about speeding things up or tightening rules. It's about redefining how the U.S. immigration system expects people to live, work, and stay connected to the country. In the next few minutes, I'll walk you through what changed, who benefits immediately, who needs to be more careful than before, and what actions you should start thinking about right now. No panic, no exaggeration, just clarity so you can move forward with confidence. Let's start with one of the biggest and most positive shifts this law brings, especially for people who've been stuck waiting far longer than they ever expected. For years, employment-based green card applicants have lived in a state of limbo, watching priority dates crawl forward while careers, families, and life plans stayed on pause. This new law directly targets that pain point. One of the most impactful changes is a legally mandated processing timeline for most employment-based green card applications. Under this law, immigration authorities are now required to process these cases within 180 days. That alone is a dramatic shift from the multi-year uncertainty many people have endured. To make this possible, the government is allocating new funding to hire additional immigration officers, modernize systems, and finally move away from outdated workflows that caused so many delays in the past. What this means in real life is momentum. If you're on an H-1B visa, if you've been waiting on an I-140 or adjustment of status, or if your priority date has felt permanently frozen, this law could significantly shorten your wait. There's also a major expansion of premium processing. Until now, premium processing was mostly limited to temporary visas or extensions. Under this new law, certain green card stages can now be expedited as well, potentially delivering decisions in as little as 30 to 45 days for those who choose that option. This doesn't mean everyone will be approved instantly, and details are still being rolled out. But the direction is unmistakable. The backlog crisis has been acknowledged at the legislative level, and action is finally being taken. For applicants from countries that have historically faced the longest waits, especially India and China, this is a long-awaited signal that patience is no longer being ignored. Relief may not come overnight, but for the first time in years, there is a clear sense that the line is actually moving. However, while this law brings speed and opportunity for many applicants, it also draws a firmer line for people who already hold green cards. If you are a permanent resident, this part is especially important to understand. The new law introduces stricter scrutiny around how much time green card holders spend outside the United States. In the past, many people believed that returning to the U.S. once a year was enough to stay safe. Under this new legislation, that assumption no longer holds. If you spend more than 6 months outside the U.S. without a re-entry permit, your case can now be flagged for review. If you remain outside for more than a year, you could face serious risk of losing your permanent resident status unless you can clearly prove strong ties to the United States. These ties include things like full-time employment, property ownership, close family living in the U.S., and consistent tax filings. The government is making it clear that a green card is meant for people who actually reside in the United States, not those who treat it as a long-term travel document. There's also a new compliance requirement that many people might overlook. Green card holders will now be required to file a simple yearly confirmation of residence online. It takes only a few minutes, but missing it could trigger unnecessary problems. This may sound stressful at first, but it's important to keep perspective. If you live in the U.S., work here, pay taxes, and genuinely maintain your life in this country, this law is not aimed at you. It's designed to prevent misuse, not punish real residents. The key takeaway is awareness. Habits that were once casually accepted now matter more. And staying informed and compliant is the best protection you have. Now, let's talk about one of the most exciting parts of this new law, especially if you work in healthcare. Because this change is not small and it's not symbolic. It's a direct response to a national crisis. The United States is facing a severe shortage of healthcare workers, and this law finally turns that reality into action. Under the new provisions, nurses, doctors, medical assistants, therapists, home health aides, and several other healthcare professionals now have access to a fast-track pathway to permanent residency. If you've been working in the U.S. on a temporary visa in a healthcare role, you may now be able to apply for a green card without going through the long and exhausting labor certification process that used to slow everything down. On top of that, the law creates a special visa allocation just for healthcare workers, adding 25,000 green cards every year outside of the usual caps. That means less competition, faster decisions, and more certainty. This is especially meaningful for healthcare professionals from countries like the Philippines, India, Pakistan, Nigeria, and many others who have kept hospitals, clinics, and care facilities running during some of the most difficult years in recent history. The message from the government is clear: your work matters, and they want you to stay. Just as important, this law includes new protections against exploitation. Employers can no longer use immigration status as leverage to underpay or mistreat healthcare workers. Fair wages and proper working conditions are now part of the legal framework. If you're in healthcare, this is not just an opportunity, it's a turning point. Start organizing your documents, understand your eligibility, and seek proper guidance because this window may move faster than many people expect. But while this law opens doors in powerful ways, it also brings back a rule that has many people worried, and understandably so. The public charge rule has been reinstated and strengthened, which means immigration officers will now place more weight on financial self-sufficiency when reviewing green card applications and renewals. This does not mean that using public benefits automatically disqualifies you. That's a critical distinction. If you've needed help because of a medical emergency, a temporary job loss, or a family crisis, brief use of assistance will not destroy your case. What the law focuses on is long-term dependency. If someone has relied on certain public benefits like Medicaid, food assistance, or housing support for more than 12 months within a 3-year period, their application may face closer scrutiny. Officers will look at the full picture, whether you're employed, whether you have income or savings, and whether you can reasonably support yourself and your family moving forward. This shift can feel intimidating, but it's not meant to punish people who struggled during hard times. It's meant to prioritize applicants who demonstrate stability and independence. If you're planning to apply for a green card or adjust your status, now is the time to be intentional. Focus on consistent employment, even if it's modest. Build savings where possible. File taxes correctly and on time. Show contribution, not perfection. This standard is tougher than before, but it is manageable with preparation and awareness. The goal here is not fear, but readiness. For many families, this next part of the law is the most emotional because it finally brings certainty where there has been none for decades. The new law creates a permanent legal pathway for dreamers. People who were brought to the United States as children, grew up here, went to school here, and built their lives here, yet have lived year after year with uncertainty. Under this legislation, eligible dreamers who meet clear criteria such as continuous residence, no serious criminal history, and either education, employment, or military service can now apply directly for green cards. This is not temporary protection. It is not something that expires every 2 years. It is permanent legal status. For the first time, dreamers are being offered stability instead of survival. The law also goes a step further by allowing approved dreamers to sponsor certain family members, opening a path for parents, siblings, and spouses who have been separated by legal barriers for years. Processing for these cases will be prioritized with a target timeline of about 12 months, and there is even financial assistance available to help cover application fees. Recognizing that many dreamers were blocked from higher-paying opportunities simply because of their status. This is a moment of long overdue recognition. The message is powerful and clear. If you grew up here, contributed here, and followed the rules, you belong here. If you're a dreamer watching this law is not just a policy update. It's a turning point. Preparation matters, documentation matters, and guidance matters. But for the first time, the path in front of you is real, stable, and achievable. Now, let's shift to another group that this law directly empowers: entrepreneurs, innovators, and job creators. For years, talented founders were forced to leave the United States not because their ideas failed, but because the immigration system had no clear place for them. That changes with this new law. A groundbreaking startup visa program has been introduced, allowing foreign entrepreneurs to apply for green cards if their businesses are actively contributing to the U.S. economy. If you founded a startup in the United States, raised at least $250,000 from qualified investors, and created a minimum of 5 full-time jobs for US workers, you may now qualify for permanent residency without relying on employer sponsorship. This is a major shift. It recognizes that innovation doesn't always fit into traditional employment categories. The law also expands and adjusts the investor visa program, lowering the minimum investment requirement in certain rural or high unemployment areas to $500,000, making it more accessible to families who want to invest, build, and grow in the U.S. economy. At the same time, the law strengthens fraud protections to ensure only legitimate businesses and investments qualify, protecting both applicants and the system itself. This isn't about buying status. It's about building value. If you're an entrepreneur, a founder, or an investor with a serious vision, this law is an invitation. It rewards initiative, job creation, and long-term commitment. The opportunity is real, but so is the responsibility. Strong planning, real impact, and proper documentation will be essential for those ready to take that step. The door that was once closed is now open. There is one final change in this new law that applies to everyone, no matter how you obtained your green card, and it's something you'll need to stay on top of going forward. Starting 6 months from now, all green card holders will be required to complete a biometric renewal process every 10 years. This includes updated fingerprints, a new photograph, and iris scans. The purpose behind this isn't punishment or control, it's modernization and security. The government is working to eliminate outdated records, reduce identity fraud, and ensure that permanent resident documentation reflects who you are today, not who you were decades ago. The process itself is straightforward. When it's time to renew, you'll be scheduled for a visit at a USCIS application support center. Most appointments take under 30 minutes. What's important is that it's mandatory. Missing it or ignoring renewal notices could create unnecessary complications, even if your underlying status hasn't changed. Along with this, the law introduces a digital green card component. You'll still receive a physical card, but you'll also have access to a secure digital version through a government app. This digital card can be used for employment verification, identity confirmation, and certain travel-related processes. It's encrypted, protected, and designed to make everyday interactions simpler. Change like this can feel overwhelming, especially when your immigration status is involved. But this shift is about efficiency and protection. If you stay organized, update your information, and respond to notices on time, this process should be smooth and uneventful. Think of it as routine maintenance for something you've worked incredibly hard to earn. When you look at this new immigration law as a whole, a clear pattern emerges. The system is becoming faster for those who contribute, stricter for those who misuse it, and more modern for everyone involved. There are real opportunities here, but they come with responsibility. Awareness matters more than ever. Deadlines matter, compliance matters, and preparation can make the difference between peace of mind and unnecessary stress. If you're a green card holder, this law is a reminder to stay engaged with your status, not passive. If you're still on your journey, it's proof that progress, while slow, does happen. Immigration has never been just about paperwork. It's about stability, family, work, and the ability to plan a future with confidence. If this update helped bring clarity to a complicated moment, take a second to like this video so more people see it. Share it with someone who might be affected by these changes, and subscribe if you want calm, clear updates you can actually trust. Your journey matters, and staying informed is one of the strongest tools you